iyi bir şehirdi.
Your Honors, I want to return to the issue of war crimes jurisdiction, as this came up many times in the course of this trial. The police jurisdiction over the investigation of war crimes committed by civilians was also established by Stanišić's own witness, Simo Tuševlijak, who authenticated a number of criminal reports for war crimes committed against Serbs that he filed with the civilian courts in 1992 and 1993. The defense contend that it was the policy of the accused that all war crimes should be investigated regardless of the ethnicity of the victims. As addressed comprehensively in our final brief, the evidence does not support this contention. Rather, following the instructions of the RSMUP leadership, the police focused their resources exclusively on investigating war crimes committed against Serbs. For example, although Goran Mačar claimed that in August 1992 he instructed his RSMUP crime inspectors to investigate all crimes committed by the Yellow Wasps, including war crimes, this was clearly not the case. As Mr. Hannes has discussed, Mr. Mačar's testimony is subject to serious questions of credibility. But telling is the list of questions found in the notebook of an RSMUP crime inspector that was used during the interrogations of the Yellow Wasp members. The questions are limited to issues of vehicle thefts, sales of apartments, and lists of unwanted Serbs. None of these questions pertained to war crimes committed against non-Serbs. This can be found at P403. Equally telling are the official notes from the police interviews of the members of the Yellow Wasps, many of which are in evidence in this case, and none of which mention war crimes committed against non-Serbs. If we can look at yes, we have the next slide up. Your Honors have also heard evidence that the military prosecutor's office transferred jurisdiction over Duško Vučković, the only Yellow Wasp member who had at one time been in military custody, to the civilian authorities after determining that he was not a member of the VRS. And yet, the police never fulfilled their duty to supplement their criminal report to include crimes, any crimes, beyond the vehicle thefts which were at issue in the original criminal report they filed with the Bijeljina prosecutor. By the way, this evidence also shows that the military did not exercise jurisdiction, criminal jurisdiction, over paramilitary groups, such as the Yellow Wasps, unless and until these groups were absorbed into the Army under Article 9 of the RS law on the Army. Contrary to the assertions in the Stanišić defense brief, the police did not hand over the members of the Yellow Wasp to the authorities in Serbia because the prosecutor and the courts in Bijeljina were not functioning. Your Honors have heard from former Bijeljina judge Simeunović, who was assigned to this case, and nothing in her testimony even suggested that she or the prosecutor were unable to proceed with the prosecution of the case against the Yellow Wasps. Nor did the police hand over the members of the Yellow Wasps to the Serb authorities. These paramilitaries were released from detention by the investigative judge because, as she explained, the police failed to charge them with anything more serious than vehicle thefts. And she was unaware of any war crimes allegations against them. Some of the Yellow Wasp members returned to Zvornik, some left for Serbia, and others were absorbed into the VRS Drina Corps. In its year-end report, the RSMUB confirmed that its interest in war crimes was limited to those committed against the Serb population. It states, the focus of the operative work in CSBs and SJBs was on detection, documenting, and reporting members of the enemy army who had committed acts of genocide against the Serbian people, torched or destroyed immovable property, cultural and religious monuments, and other assets. Turning to police crimes against non-Serb population, although the RSMUB stated in its year-end report that criminal reports were brought against 29 RSMUB employees between April and December 1992, this can be found at P625, page 27. Mr. Vasic, utilizing the police crime logbooks as well as his resources as head of the RSMUB police, was able to identify only four cases in which police officers were charged with serious crimes against non-Serbs in the indictment municipalities during this period. The first instance was against Radomir Boškan and the two other members of the CSB Banja Luka Special Police Detachment. These are the police officers that Župljanin played a role in their escape from detention. Contrary to the assertion in the Župljanin brief, Župljanin did not request the prosecution of Boškan and his co-perpetrators. The criminal report emanated from the SJB, which, as Your Honors heard, was consistently critical of this special police detachment and the crimes they were committing around the municipality. It did not emanate from the CSB as it should have. Nor were these police officers ever prosecuted for their crimes. The second instance was for a robbery committed by a former member of the CSB Banja Luka Special Police Detachment in October, most likely while he was subordinated to the VRS. The third instance was the criminal report against certain, but not all, police members of the Miće group in Teslić. Milan Savic, the CSB Doboj deputy chief, who was the police leader of the group, was never charged with these crimes because the MUP leadership deemed it was not expedient to criminally charge a high-ranking police official. Those officers who were charged were subsequently released from detention and have yet to be prosecuted for their crimes against non-Serbs in Teslić. And the fourth instance was against an SJB Prnjavor police officer for the robbery of a non-Serb. Beyond these four instances, there is no evidence in this case of any other police officers charged with serious crimes against non-Serbs during the indictment period in the 20 indictment municipalities. Equally evident is the accused failure to discipline their subordinates for crimes against non-Serbs. For example, with regard to CSB Banja Luka, the chamber heard the evidence of Radomir Rodić regarding the disciplinary cases filed against Serb police officers for offenses committed between April and December 1992 that were recorded in the CSB Banja Luka disciplinary case logbook. The chamber heard that Župljanin terminated police officers for failing to show up at work, for firing their gun at a stop sign, and killing Serbs. No police officers were disciplined for crimes committed against non-Serbs. Now, the Župljanin defense assert in their brief that Rodić testified that the CSB Banja Luka disciplinary case logbook was incomplete an incomplete record of the disciplinary reports against police officers. This mischaracterizes his evidence. Rodić testified that for some of the entries involving multiple police officers who co-perpetrated the same disciplinary offense, the name of only one of the police officers is listed in the logbook, followed by the notation "and others." Equally incorrect is the defense assertion that disciplinary proceedings for a criminal offense could not be initiated or completed if a police officer voluntarily resigned. Rodić testified that in such instances, disciplinary proceedings continue despite the resignation. And there are examples of this in the CSB Banja Luka disciplinary logbook. With regard to the region covered by CSB Doughboy, when Milosevic was asked whether he recalled instituting any disciplinary proceedings against his subordinates for offenses related to the mistreatment of non-Serbs, he was only able to recall a case against CSB Doughboy Crime Inspector Sholaya. As it turned out, Milosevic's disciplinary decision, P2347, showed that he terminated Sholaya's employment for the opposite reason, for assisting non-Serbs escape to Belgrade using false identification cards, a disciplinary decision that Stanišić upheld in December. In fact, a protected witness testified that it was not uncommon for Serb police officers to be disciplined for helping non-Serbs during this period. I reference transcript page 3727. In other regions, the Chamber has heard evidence that SJB Vogošća Chief Maksimovic was disciplined for task vehicle thefts, but not for the crimes that occurred under his watch at the bunker and other locations, other detention facilities in Vogošća. And SJB Visegrad police officer Sredoje Lukic was disciplined for releasing a Serb prisoner and not reporting to work on occasions, but not for the house fire on Pionierska Street or any of the other crimes that he and police officer Milan Lukic committed against the non-Serb population in Visegrad. The Stanišić defense contend that Stanišić lacked the authority to initiate or decide, in the first instance, disciplinary proceedings against his subordinates. This was not the case. As Tomislav Kovac testified, Stanišić was the one person who had to make the decisions on both accepting people into the service and dismissing them from the service. Transcript page 27076. When Judge Hall asked Dragan Andan whether it was possible for the minister to both initiate and decide a disciplinary case, Andan answered in the affirmative. Transcript page 21780. In fact, Article 115 of the RS Law on Internal Affairs gave the minister the power to decide who could initiate disciplinary proceedings. And Article 5 of the RS MOOC Wartime Disciplinary Procedures stated that a disciplinary case, quote, may be initiated at the initiative of any worker of an internal affairs organ, which must have included the minister himself as well. 1D54. Furthermore, there are examples where Stanišić did exercise his authority to discipline his subordinates. As Mr. Hannes pointed out, he dismissed SJB Bilina chief Andan for failing to follow proper procedures regarding the use of a confiscated poker machine, and he dismissed SJB Bilina crime police chief Danilo Vukovic for drunk and disorderly behavior at a bar. Your Honors, although the ultimate punishment under the police disciplinary procedures, termination of employment, was an insufficient form of punishment for any of the police crimes alleged in the indictment, the failure of the accused to ensure that their subordinates were disciplined for crimes against non-Serbs is relevant for for at least 3 reasons. First, had they disciplined their subordinates for these crimes, it would have sent a message to the police force that such crimes would not be tolerated. Secondly, it would have shown to the non-Serb population that the Ars MUP was serious about ensuring that the police protect all citizens indiscriminately. And thirdly, the accused's failure to discipline their subordinates for these crimes reflected their more general disregard for crimes committed against the non-Serb population. I want to briefly address the defense suggestion that Stanisić's orders, beginning sometime after the 11th July collegium meeting, to replace Ars MUP personnel, or to place Ars MUP personnel at the disposal of the Army, was a form of disciplinary punishment. First, these orders were primarily directed at augmenting the Army with those police officers who had outlived their usefulness to the Ars MUP, as Stanišić and General Mladić had agreed during the July meeting that Mr. Hannes discussed. This can be seen by Stanisić's 27 July order, that's 1D176, in which Stanišić classifies both criminal and unneeded police officers as surplus persons to be sent to the Army. In addition, if Stanišić was serious about preventing or punishing police crimes, his orders would have expressly and explicitly stated that these surplus officers must be arrested, subjected to both disciplinary and criminal proceedings. They do not. Nor did Stanišić instruct the police to inform the VRS of the criminal conduct of police officers they were putting at the Army's disposal. Thus, a police officer who mistreated non-Serbs at Omarska or at Luka camp could have very well ended up guarding non-Serb detainees at Manjača or Batković. All Stanišić was doing was shifting a problem from one organ to another. In order to justify their inaction in punishing their subordinates, both accused argue that the police committed these crimes while resubordinated to the military. Ms. Corner has already addressed how the evidence does not support the defense suggestion that the police were almost entirely resubordinated to the military during the indictment period. But even if the trial chamber were to accept the defense's extreme interpretation of resubordination, this did not diminish the accused's authority or duty to prevent and punish their police subordinates. The defense are misguided in their assumption that the principle of unity of command means that a resubordinated police officer cannot have 2 superiors. As a matter of law, a subordinate can be under the command of more than one superior, and each superior can be held responsible for the subordinate's crimes. I direct the trial chamber's attention to the Struger trial judgment, paragraph 365. Moreover, there is nothing novel about Ars MUP commanders retaining control over MUP forces even when such forces have been temporarily resubordinated into the Army. In the Popović case, the trial chamber found that the Ars MUP forces resubordinated to the VRS still retained their internal chain of command, and as a result held Lubomir Verovčanin, deputy commander of the Ars MUP Special Police Brigade, had effective control over such resubordinated MUP units. I direct the trial chamber's attention to paragraphs 3, 184, 1567 to 1569. Your Honors, while this is not controlling authority, the prosecution submits it is highly persuasive. Now, while the VRS may have assumed responsibility for assigning combat tasks to resubordinated police officers during a particular combat operation, the Ars MUP...
sorry to interrupt you, Mr. Olmsted. I see that you have cited Strug and Popović, which you admit may be persuasive to us in our findings. But your own proposition that as a matter of law, a subordinate can be under the command of more than one superior, and each superior can be held responsible for the subordinate's crimes. Is there anything in the either the evidence or the representations before this tribunal to which you could refer us to support your assertion?
I mean, Your Honors, the position of the prosecution is that the police maintained really signalless of command over the MOOP forces, except for the purposes of operations on the front lines. And so the evidence, and we suggest the evidence reflects that. What I'm simply proposing is that there is jurisprudence before this tribunal that it makes no difference, because you can have parallel chains of command. And there is quite a bit of jurisprudence on that issue. To go into more detail, we'd ask that we be given a few minutes, perhaps tomorrow, to address this and point the trial chamber to the places where we deal with it in our final brief, as well as in the evidence.
Your Honours, I'm sorry to interrupt, Mr. Ornstead, but I was going to ask Your Honours at the end of today, in the light of what Mr. Zečević raised today in respect of Mr. Hannes, his address on the Stanišić interview, that Your Honour, even though Your Honours have ruled that we can't do this in writing, Your Honours, we would say that, of course, we filed our briefs at the same time. We didn't know what the defence were going to say about the law. In the light of this and the intervention into Mr. Hannes's address, we would ask that on Friday, Your Honours grant some time to deal with matters of law. And can I just put it that way at this stage?
It may appear that that may be a sensible course.
Thank you, Your Honors. The RSMOOP retained ultimate command over their police officers, and this is shown by the evidence that both Stanišić and Župljanin had the power to organize their subordinates into war units and provide them with training and equipment, the power to decide whether and when to resubordinate police units to the VRS, the power to participate in the command of combat operations of these war units, as Župljanin did in Orašje in November of 1992, and the power to withdraw these units from the front lines when they deemed it necessary, as Ms. Corner discussed during her statement. Indeed, Stanisić's 15 May order establishing war units instructed that all such units be under the direct command of an RSMOOP commander, and he also created a staff headed by himself to oversee these units. These measures were clearly taken to maintain RSMOOP control over any police units engaging in combat activities with the VRS. The accused also retained the authority to discipline and criminally charge police officers for crimes committed while resubordinated. With regard to disciplinary measures, as the ultimate punishment was termination, this punishment logically could only have been meted out by the RSMOOP. Even in 1994, when the RS law was amended to place the RSMOOP within the armed forces during a war or imminent threat of war, the law explicitly preserved for the RSMOOP the power to discipline its police officers. That's L317. With regard to criminal investigations, as Mr. Jovicinac explained, the resubordinated police officer did not fall within the definition of military personnel under the law of the Army, and therefore they were not subject to military court jurisdiction for general crimes or, for that matter, war crimes. This made sense. A police officer was typically resubordinated for only a short period of time, 1, 2, maybe 3 weeks, And under Article 16 of the SFRI law on the military courts, it would have been unlikely that an indictment could be filed against him before he returned to his regular police duties. Moreover, as Mr. Jovicinac suggested, the prosecution of police crimes was a delicate issue, as the RSMUP had its separate chain of command. The VRS was extremely hesitant to assume jurisdiction over police crimes, leaving it to the police hierarchy to address them. This is precisely why General Talic sent a request to CSB Banja Luka to take action against police deserters in October of 1992. That's 1D411. If we can look at, yes, we have the slide on the screen. In fact, this chamber has in evidence an example of Župljanin exercising disciplinary and criminal jurisdiction over police officers for crimes committed while resubordinated. In an 18 October dispatch regarding police who on 17 October refused to obey VRS orders while resubordinated, Župljanin ordered that all workers who refused to obey orders were to be suspended and criminal measures filed against them. Look at the next slide. To show that these were not just hollow words, if we look at the CSB Banja Luka disciplinary case logbook, we see an entry against Ljubiša Nikolić and others from SJB Gordishka for a violation committed on 17 October 1992, and the result was termination of employment. Finally, I want to address the defense contention that certain of the more notorious SJB chiefs, such as Todorovic, Drlacha, and Koroman, were untouchable, immune to any attempts by the accused to discipline, remove, or criminally investigate them. The defense rely primarily on two arguments. First, they contend that because the crisis staffs appointed these individuals SJB chief, the accused were powerless to discipline them. Mr. Hannes addressed this issue. He discussed variant A and B instructions, and in fact, they called for, in the interim period, when a municipality was taken over, for the municipal authorities to appoint SJB chiefs temporarily until the RSMUP was in a position to take over the duty of appointing police in those particular municipalities. Not all of them, but some of them. Stanišić was aware of this, and that is why on 25 April he issued a decision in which he ordered his CSB chiefs to obtain preceding agreement of the Ministry of Interior before distribution of employees onto next jobs and assignments. Your Honors, the operative word being next. To avoid ambiguity, he clarified under item 4 the decisions which deal with taking over the distribution of the employees within the MUP, Ministry of Interior, of the Serbian Republic BH, and were issued before issuing this decision, have all legal effects on persons named. In other words, Stanišić was ratifying the prior appointments of SJB chiefs and other members of the police leadership. If, as the Stanišić defense assert, Todorovic was appointed by the Bosanski-Shalmutz crisis staff on 28 March, and if Koroman was appointed before 1 April by the BIH MUP, then Stanisić's 25 April order effectively confirmed those appointments. With regard to Drlacha, the accused ratified his appointment on 30 July 1992, applying it retroactively to 29 April. That is, the day before the takeover, the Serb takeover of Prijedor. Contrary to the assertion by the Stanišić defense, Župljanin's mention in the written decision that this appointment was made with prior approval of Stanišić was not just standard language. We can see this by comparing Drlač's appointment with that of Dusan Janković as commander of SJB Prijedor. Under Stanisić's 25 April order, both positions, both appointments, required the formal approval of the Ars MUP. But we can see that while Drlač's appointment mentions the prior approval of the minister, Jankovic's appointment does not. Your Honors, there are examples and evidence where the Ars MUP removed SJB chiefs who were initially appointed by the municipal authorities. Mr. Hannes has already mentioned Marinko Vasilic, who there's no contention that he was appointed by the Zvornik crisis staff. However, Stanisić had no problem removing him in October or November of 1992 for failing to report to the Ars MUP. And while the prosecution maintains that Boro Maksimovic, chief of SJB Vogošća, was appointed by Stanisić, the defense contend that the crisis staff appointed him. If this is the case, this is yet another example where the Ars MUP was able to remove an SJB chief appointed by municipal authorities. The second argument raised by the defense is that it would have been dangerous for the accused to remove these SJB chiefs from their positions in 1992 through the use of force or other means. This raises a question, Your Honors. Dangerous to whom? If the defense are suggesting it would have been dangerous to the accused or their police subordinates, the Ars law on internal affairs required them to put the safety of citizens before their own. And indeed, the police did not hesitate putting their lives on the line when it came to the issue of vehicle thefts. If the defense are suggesting that the safety of the civilian population would have been placed at risk, then they are ignoring the evidence that the lives of the non-Serb population were already in grave danger and remain so long as these SJB chiefs remained in their positions. While it is easy to pass the blame to these SJB chiefs, particularly in the case of Todorovic and Drlača.
Would the speaker please slow down for the sake of interpreters?
Evidence to the contrary. The fact is that these SJB chiefs were kept in their positions because they were effective and essential participants in the joint criminal enterprise. Recall that Župljanin was part of the ARC delegation that visited Omarska and other detention facilities in Prijedor in July. Immediately after that visit, Brđanin announced to the media on behalf of the delegation that Prijedor is an example of a job well done. P. 1378. In an interview before assuming his new position as Ars MUP assistant minister in 1993, Drlača showed no signs that he placed himself above his superiors or the law and internal affairs. He stated, "If something has not been done well, then I am to be replaced, not them," referring to his subordinates, because they were carrying out my orders and the orders of Banja Luka CSB and the MUP minister. Contrary to the assertion by the Župljanin defense, Drlača was not removed by the Prijedor crisis staff. Rather, Drlača stated during this interview that he urged the Ars MUP minister to replace him in order to allow the dust to settle. Stanisić's actions and inaction during his second term as Ars MUP minister in 1994 reflect his state of mind in 1992 with regard to these SJB chiefs. He appointed Drlača chief of CJB Prijedor in April 1994. He appointed Koroman chief of CSB Sarajevo police tasks and duties in January 1994. and Chief Inspector of RSMUP Police Special Operations in May 1994. And as for Todorovic, he remained in his position as SJB Bosanski-Shalmat's chief throughout Stanisić's second term as minister. Your Honors, it is not that the accused were unsuccessful in their efforts to remove the SJB chiefs from their positions or to punish them for their crimes. It is that they took no actions to do so, but instead chose to praise and promote them.
Your Honours, in order that the general public doesn't think that the Office of the Prosecutor is entirely staffed by white male North Americans, I'm going to conclude what the Office of the Prosecutor wants to say in this case. And, Your Honours, I want to do so, please, by...
And I would remind you that you have 37 minutes.
And I'm well aware that, Your Honour, we've been timing ourselves very carefully and checking with the court. Your Honours, we want to look, in conclusion, in a little detail at one of the major and most notorious massacres that took part in 1992, and which is one of the crimes charged in this indictment, and that is that of Koryachanski Stieni. Your Honour, because really what happened there on the 21st of August 1992 and thereafter encapsulates all the themes, we say, that we have attempted to address throughout the course of the last day and a half. The unwarranted attacks on non-Serb areas, the rounding up of unarmed civilians by a mixture of police and military personnel, their incarceration in a detention facility, the loading onto buses of prisoners to take them out of Serb-controlled, Serb-held areas, the whole-scale killing of those being transported, and the subsequent deliberate, flagrant omission by both of the accused in this case to do anything about the known killers or discipline the officer who was directly in charge of them. Now, very few people, very few men survived the killing. One of them was ST65, from whom Your Honours heard, if only briefly, but his testimony in a previous case came in. He was a native of the Prijedor municipality, who on the 20th of July was taken with his father from his village by armed, uniformed men, some of whom were in the olive drab type camouflage uniforms and some in police. He was able to identify a photograph of the police uniforms, and he had reason to know from his background, which as he's a protected witness I'm not going to go into, what police uniforms looked like. He and the rest of his village, in response to the disarmament order, had given up all of their weapons and uniforms sometime before he was taken. And he and his father and the other men, not only from his village but from elsewhere, this was part of the attack on the Brdo area of Prijedor, was taken to Ternopily. 1 month later, buses arrived, and the prisoners were told to board them. They were driven from Ternopily to the crossroads where Banja Luka and Kozarac, effectively the roads there, meet. And there they linked up with other buses. The convoy then set off towards Travnik. The escort, and there is no dispute about this at all, Your Honours, was the Priador, or part of the Priador intervention platoon. Whilst they were on the buses, the prisoners were robbed of their valuables and money that they had left. Yet another facet of the persecutory activities of the RSMUP during this period. Once they reached the area of Korycianskie Stieny, the men were ordered out of the buses and in military fashion, 2 by 2, were ordered towards the edge of the abyss and ordered to kneel down there. Can we have a look for a moment? I know your honours have been there. Just to remind yourself of the view that these men must have had as they looked down on the road over the abyss. The markings, of course, were made by one of the witnesses. This is how ST65 described what had happened to him, not in this trial, but in the previous trial, and the transcript is P176901 at page 6905. When we knelt down, we could see this enormous abyss below us. And then I could hear the person saying, person behind me, one of the intervention platoon, "Here we exchange dead for the dead and living for the living." That's when the shooting started from firearms. I saw that people were falling down into the abyss, and then my father pushed me there into the precipice. He fell, became unconscious, and found himself, when he woke from when he regained consciousness, with a broken ankle. Shortly thereafter, whilst he was still there, men came down, he said, and were shooting survivors in the head. He does not know why or how he survived. Eventually, he managed to crawl to an inhabited area. He was found there by members of the military. He was taken to Skendavakov, and from there to Banja Luka Hospital. On the way, a statement was taken from him, and he said, tape recorded. He was able to recognize some of the intervention platoon who were involved in the massacre. A massacre of approximately 200 men, including the witness's father. Whilst he was in hospital in Banja Luka, he gave a further statement, as did 2 or 3 of the other survivors. So, we have in hospital witnesses, victims in Banja Luka. What happened about the investigation? The killings were reported in the evening of the same day, the 21st of August, to Lieutenant Colonel Polic when he came back from a meeting at headquarters. He was the officer in charge of the unit that was stationed in the area. He immediately went out, although it was night, inspected the area, saw the blood, and he sent a telegram both to the 1st Krajina Corps and to the CSB Banja Luka. And this is the telegram that he sent. Addressed to the 1st Krajina Corps, he talks about the refugee convoy moving towards Travnik. The Priador and Sanski Most CSB police were escorting the convoy, so clearly he had received by the evening of that day very, very accurate information. At the same time, the convoy stopped in the area of Korycianskie Stieny. Refugees were taken out, and genocide against the civilians was committed by killing them in various ways and throwing them into the river canyon. Numbers of police members participated in the liquidation, the units and individuals from the 22nd Light Infantry Brigade had nothing to do with this. And we request the following measures be taken. One of the features that we've been attempting to explain through this case is that the shoveling of blame elsewhere. And here the Army is saying absolutely nothing to do with us. Correctly, as it turned out on this occasion, this is police. Župljanin was aware of what had happened by the very next day. The defense quote, forgive me, honest, what he said to Mr. Buhavats, apparently with approbation. And this is paragraph 65. Mr. Buhavats was the man who died, the technician, forensic technician from Banja Luka. And his statement over OTP objections was admitted, his interview rather with the OTP. Paragraph 65, the defense say this of the Župljanin final brief. Župljanin was also notable for his efforts in investigating crimes committed by Serbs against non-Serbs. When he heard about the massacre at Korječanske Stijene, his first reaction, as recorded by Branko Buhavats in an interview with the office of the prosecutor, was one, in inverted commas, of horror, with him explaining to Buhavats, chief of forensics in Banja Luka, forgive the expression, but I think it has to be repeated, fuck. Some jerks did something stupid. Your Honours may think that is a thoroughly inappropriate remark to have been made under any circumstances when you're being told that your police have massacred 200 people. It is, however, possibly explicable by the fact that this happened roughly 2 weeks after the camps at Prijedor had been exposed to international attention by ITN and other news media, and therefore, no doubt, the Bosnian Serbs were very concerned about the possibility that this might attract even more unfavourable publicity. According to the witnesses who attended subsequent meetings, it was openly admitted, the word used by at least one witness was boasted by Drill Archer, that it was the Prijedor police who had committed the killings. The only orders given by Župljanin at this stage were that the bodies should be recovered. And we would suggest that he had at the back of his mind, as I say, the international media. Clearly, as the scale of the massacre became clear, higher-level government officials began to attend meetings at Banja Luka. Deputy Minister Avljaš was at one, Defence Minister Subotic at another. Again, the focus was not on the arrest of the perpetrators, but on the recovery of the bodies. On the 31st of August, Mićo Stanišić, who had been told, according to what he said in an interview to the Office of the Prosecutor some 3 days afterwards what had happened, issued his one and only order in respect of this killing. It is P870. No attempts to pursue the matter or give instructions to Assistant Minister Kovac or Mačar after this order were made. Župljanin then waited until the 11th of September to send this order to Drill Archer, and this is P1380, and it really combines the two. Mićo Stanisić's order, issued on the 31st of August, you can see, orders full investigation in accordance with the laws and regulations of the killing of 150 Muslim people in the area of Skender Vakuf. You will inform this ministry immediately about the results of the investigation and in the case that the above-mentioned allegation is confirmed, you will start legal proceedings against the perpetrators. Well, by that stage, everybody knew and had been discussing that it was the Priador intervention platoon who had committed these murders. No explanation is given, or is available to us, as to why that order wasn't forwarded until the 11th of September. Between the 11th of September and the 13th of October, Župljanin and Drilacher engaged in a correspondence over the names and whereabouts of the officers who were involved. And those are set out, that correspondence is set out in paragraph 990 of our final brief. On the 8th of September, Župljanin sent an unknown perpetrator report to the Banja Luka prosecutor. That's P1567. The report makes absolutely no mention of the fact that Priador police were involved, although that was known to all, and in particular Župljanin, by the 8th of September. On the 30th of September, the prosecutor's office asked the police to continue investigating and to identify and arrest suspects. That was it. Nothing further was done, neither by Mićo Stanišić to make any further inquiries, nor by Župljanin. The matter didn't resuscitate itself, really, until 1999, when the file was reopened. When Mićo Stanišić returned as minister in 1994, he took no action about it. His reaction to all of this, when interviewed by the office of the prosecutor, was to blame Župljanin. The two accused in this case have not run sometimes known in the common law world as a cutthroat defence, in other words, where each blames the other. They have run a defence together. However, when he was first interviewed, Mićo Stanišić had this to say. The first reference to it is in it's not up, P2302 at pages 2 to 3, when he was being interviewed and asked questions. He said this. The context, I suppose we ought to put it in, is when he returned in 1994, he'd been given information about war crimes, and he was being asked what information that he had. And he started off by saying, this at page 1, that he personally did not have any information about war crimes. There were public rumours, particularly through the media, and particularly because I was in a position here to listen to what foreign and local reporters were saying. At page 2, he went on himself to bring up Koryachanske in 1992, when Koryachanske happened, I did whatever I could in my capacity. I sent an order to form both the military and civil, because I didn't know whether it was in the jurisdiction of the civilian or military office of the prosecutor, an order that an on-site investigation should be carried out, and that all measures envisaged by law should be undertaken to solve this case. And we've seen the one and only order. He goes on to give a long answer and then said this. Certain activities, and this is at page 3, certain activities were conducted amongst the investigating judge and the prosecutor between 1990 and late 1992, at the end of 1992. But in 1993, all activities related to this case were terminated. That was one of the fundamental reasons why I removed Stojan Župljanin from his position. he was asked why you removed him from his position in 1994, which we say is incorrect in any event, because I had left in 1992, so it wasn't possible for me. And then he goes on to deal with that. Later, and this is at P2310 at pages 20 to 22, he said, "It was of special interest for me to solve Koryachansky-Stiene, which was what I mentioned 2 or 3 days ago. And for that reason I assigned all chiefs of centres at that time to different tasks, because I was not able to exclude them." He was asked what he meant by exclude. He said, "I didn't have such authority, but I moved all the chiefs of CSBs where they worked so they wouldn't represent an obstacle to the investigation." And one of the themes that has come out in this case is that nobody who knowingly committed crimes ever seems to have been removed. They all got promoted, Drilacha being the obvious example. As soon as I had replaced Stojan Župljanin from the position of chief of centre, he went to Krajina in Croatia to become the advisor to Martic. And then he went on to deal with, he was then asked, "Were there any particular chiefs that you were concerned about?" Stojan Župljanin, but a commission was set up. Actually, the chiefs of administration were ordered, together with their teams and inspectors, to analyse the work of the MUP from the beginning until 1994. Question: I'm sorry, you were concerned in particular about Župljanin and no other CSB heads. Well, but through Župljanin, the idea was to obtain the information through Župljanin why nothing was done in 1993 regarding the case of Koryachansky-Stiene. Because both then and now I am convinced there was an influence, someone did influence the hiding of the perpetrators or trying to cover for the perpetrators. Now, Your Honours, we do not ask, Your Honours, to rely on that at all. Indeed, Mr. Župljanin wasn't present at that interview to confirm or deny it. We say it's yet another example of trying to shift the blame, his own responsibility, to someone else. In September and October, in September or October, I think it's October, but it's not clear, Župljanin was interviewed, as was Talić, about this incident. Not surprisingly, once the internationals got to hear of it, despite all attempts to stop them, they pounced on it. Was interviewed by a reporter from ABC Nightline at P1359. We can start with Talić.
Our investigation showed that no soldiers participated.
Having cleared themselves, General Talić's men turned over both survivors to the police in Banja Luka. But Police Chief Stojan Župljanin told me,
"We have no living witnesses who can confirm or deny the incident."
At least Župljanin admits the incident occurred. He says it's under investigation, and he showed us files of evidence. He even let us watch his ballistics expert examine bullets that were found at the scene. He promises.
The Serbian people will see to it that all the guilty parties are tried in a court of...
Yes, it's been slightly chopped off. But... You know, that was lie after lie. There are no living witnesses to Župljanin's certain knowledge sitting in the hospital. The witness who we've spoken about was in hospital for some months, and eventually, because he was so negligently treated, putting it at its lowest, he lost his foot. And the investigation, they don't know who it is, they knew perfectly well who had done it. The intervention platoon police who had committed the killings were sent out of the way to Han Pisiak. But, however, within weeks they were returning to Prijedor to work, to the SJB. The leader of that platoon, who gave the orders, a man named Miroslav Parash, was actually given an award by Karadžić for his police work in 1993. And Drilacha, the man in charge of the SGAB, who boasted about the killing, as your honours have heard, was promoted and also given a medal in the course of some of these awards. Your honours, in the light of what we have just gone through, we suggest that the defence assertion that Župljanin was notable for his efforts in investigating crimes committed by Serbs against non-Serbs, with specific reference to this crime, doesn't even begin to get off the ground. In conclusion, Your Honour, the Stanišić defence, at paragraph 20, invited you to conclude that the Mićo Stanišić of 20 years ago is the same person that the trial chamber has been observing during the trial. That's the word used. We suggest that's not a helpful observation, because in effect it's inviting you to say that because there are no outbursts from the dock or anything like that, it is, as is said earlier in that paragraph, you are to conclude he was not capable of committing the crimes for which he is charged. Apart from how that is supposed to reflect on his co-accused, we suggest it's obviously not the proper way of looking at the matter. Along the same lines, the final brief for Stojan Župljanin prays in aid his consistent and sincere expressions of sympathy for those who suffered, adding, "It is notable that such behaviour is not a regular practice before this tribunal," leaving aside that this trial chamber has no idea what is regular practice in other courts or has happened in other trials, nor indeed have any way of gauging how sincere those expressions were. Again, we say it's not a proper way of asking the trial chamber to deal with the case. We submit that you have to look at the evidence of what the accused did and said during and after the relevant period. An objective look at that evidence, we submit, will show that the two accused were fully committed to and did everything in their power to carry out the objectives of the joint criminal enterprise, in the full knowledge that it would involve the commission of the crimes alleged. Your Honours, the joint criminal enterprise could not have been put into effect without their commitment, their personal commitment, and the commitment of the forces that were under their command. I can do no better than repeat the words of Mr. Olmsted. During periods of ethnic conflict, the police role in protecting citizens, particularly those persecuted, is vital. In this case, we say, on the evidence that your honours have heard, they did the very opposite of what their duty should have been, and they joined in the persecution, the killings, and the like. Not, of course, in their personal capacity, but if anything, their role was more important, because they were the ones who gave the orders and set the standards. And it's for those reasons that we say, and have said in our brief, that the proper sentence that they should receive, each of them, is one of life imprisonment.
Thank you, Ms. Corner. Mr. Zečević, can you usefully make use of the 15 minutes, well, 13 minutes remaining today?
Yes, Your Honors, I have a few technical issues which I can deal with.
Yes, please proceed.
Thank you. Časni sude.
Your Honours, in our closing arguments, we will be addressing the final brief of the prosecution, their closing arguments, and will give an overview of our final brief and our positions in respect of Mr. Stanisić's criminal responsibility. Before I begin, I have several information to share of technical nature. For the sake of the transcript, let me say that we identified an error in our final brief at page 247, paragraph 683, under Roman 5, where instead of number 675, number 677 should read. Yesterday, at page 6 of the transcript, Ms. Corner referred to paragraph 53 of our final brief, specifically the first sentence of the paragraph, which lacks a reference. In fact, it is true that the reference contained in footnote 90 does not relate to the statement in the paragraph. Ms. Corner is right, and we are grateful to her for drawing our attention to it. It's a technical error. In fact, the reference to this statement was testimony by witness Mandić at T, transcript page 9626 to 9634. And it was listed in the next footnote, footnote 91, which accompanies paragraph number 54. I do apologize for these errors, which were the result of the fact that we had to shorten our submissions to meet the word limit. Likewise, at page 7 of yesterday's transcript, Ms. Corner referred to paragraph 99 of our brief, which, according to her, related to 1D116. It was stated that the conclusion made in that sentence did not follow from the document referenced. However, the reference which underlies the conclusion is the comment made by witness Vlaški in relation to 1D116, and the correct reference for that is contained in footnote 161. Your Honours, before I proceed with our closing arguments, I would like to present to the trial chamber our position with respect to what Mr. Hannes had to say at page 20 of today's transcript. However, in view of what the guidance has been by the trial chamber in response to Ms. Corner's question a moment ago, should I perhaps leave it for a later time? Friday?
Well, we haven't fully decided how we are going to deal with that. So if it's convenient, you can deal with it now. And
It is, Your Honor. Thank you very much. Dakle, časni sude danas.
Your Honours, in presenting arguments at page 20, Mr. Hannes made a comment about the inferences that the trial chamber should draw, or the elements that it should take into consideration in view of the fact that the accused in this case did not testify. I rose to object, and I apologize for that again. I am not in the habit of interrupting anyone's closing arguments, but I felt that I needed to do so. At any rate, I will present our submissions on this issue briefly. In the course of this trial, I was able to identify 3 references for our position and Article 21, Para 4G, or Rule 21, Para 4G of our statute. I also have some of the ICTY jurisprudence that I will list here and comment upon briefly. In view of the fact that they're in English, I will read them out in the original.
Perišić trial judgment. Under specific evidentiary considerations. A. Statements of the accused. It's a paragraph 35. Article 21, 4G of the statute provides that an accused shall not be compelled to testify against himself. In the present case, the accused elected not to give evidence during the trial. In accordance with the existing jurisprudence of this tribunal, the trial chamber, in the determination of his guilt or innocence, has not drawn any inference from his silence. The trial chamber here in footnote 51 cites the relevant jurisprudence. Second is Popović trial judgment, again under specific evidentiary considerations, paragraph 17. Article 21 4G of the statute provides that an accused shall not be compelled to testify. No adverse inferences were drawn against the accused who exercised their right to remain silent. And finally, Milutinović trial judgment, paragraph 41, evidence of accused. Of the 6 co-accused, only Lazarević elected to give evidence during the trial. In accordance with Article 21 4G of the statute, the chamber has drawn no adverse findings from the other accused's decision not to give evidence. Časni sude.
Your Honors, our position is that it is absolutely unacceptable to, before this tribunal, in view of the provisions of the statute and clear jurisprudence, discuss this issue at all, since various trial chambers and the appeals chamber discussed the ICTY law, case law plentifully, and in view of the rights guaranteed by the statute for the accused appearing before the tribunal. Your Honours, I would now like to move on to our closing arguments, and with your leave, I should like to do so tomorrow.
On this point that you just made, Mr. Zečević, the question I'm asked you may be thought to be unfair in the sense that I didn't challenge Mr. Hannes with the reservation that I'm now about to articulate when he made his proposition. But what I understood him to be saying was not that he was inviting the chamber to draw adverse inferences against the accused from their failure to give evidence. And as you say, there is adequate jurisprudence in support of that. But he was inviting a contrast between the fact of this choice and the representations which the accused would have given in their interviews at an earlier stage in these proceedings by the OTP. And I confess that the reason why I didn't ask Mr. Hannes about that is because I'm not clear myself as to what the evidential value of those earlier interviews is.
Well, Your Honor, I will try to explain as much as I can. The point of the matter, Your Honor, is the fact that Mićo Stanišić voluntarily gave the interview to the Office of the Prosecutor over 5 days. He gave his interview. He was asked whether this interview can be used in a trial against you. He says, I agree, you can use all this in a trial against me. The Office of the Prosecutor, by the bar table motion, offers the interview of the accused Stanišić given on that particular occasion. For the truth of its contents, it offers it to the trial chamber. That is what the bar table motion says. Therefore, in our opinion, this is the prosecutor's evidence which they offered. We accepted it because it is our client and we have nothing to be afraid of. In fact, we submit that we stand by his interview, and we stand by his interview throughout our defense presentations and throughout this whole trial. Now, Mr. Hannes, my understanding was that Mr. Hannes is trying again to challenge whether whether you should give weight or trust the contents of that interview. But again, Your Honors, it's our position that the interview has been explicitly offered by the Office of the Prosecutor. It is not the defense who offered this interview. Perhaps in that situation, he might have the grounds to make such an argument. But in case where the Office of the Prosecutor, by bar table motion, asks that this document be admitted, in their case, as their proof, I don't see how he can make this argument now. Thank you very much.
Thank you, Mr. Zečević.
May I ask, and are Your Honours going to, because we do have a reply on all of this. But
I was going to say that it looks suspiciously as if we are going. This is going to be on the agenda
yes.
for
Thank you.
Friday, but we'd see. So we take the adjournment to reconvene in this courtroom at 10 o'clock tomorrow morning.
All right, we will